Hi, everyone. Harry here to talk about a whole flurry of pretrial litigation in the Hunter Biden case. Okay, recall the context. Hunter Biden, had a couple tax violations. This is all during the lost period where he's using crack cocaine by his own admission every 15 minutes, 24 hours a day. And then where he briefly possessed a gun and then gave it back. And the parties worked out a couple misdemeanor charges for the taxes, which he had paid back with interest. And then there was going to be a diversion agreement for the gun count, meaning he kept his nose clean for a year and it would then go away. That all unraveled in court because the judge who had to preside at the plea hearing read the plea agreement, I think fairly and accurately, as giving her a role in the decision whether the charges on the gun would go forward. And she said, that's not my job. That's the executive job. And that's what made it kind of unwind before everyone's eyes, which matters really deeply here, because it's one thing for when a defendant declines to enter into a plea agreement and the government throws the book at her or him. That's how it works. It's got to work that way if you're going to be able to do plea bargaining effectively. But Hunter Biden did nothing here. He was just a sort of bystander and casualty of some not very great lawyering. And all that matters now because after that, the Republican Congress totally pilloried the special counsel in this case, David Weiss, a former Trump U.S. attorney who's been given free rein in the department to just pursue the case against Hunter, which he started when Trump was president. And they wound up bringing, for the same conduct, and with Biden's doing nothing to disavow the agreement, far more serious felony charges and a far more aggressive and even nasty kind of posture, painting him as, a dangerous drug-addled criminal. Okay, so Abby Lowell, his lawyer, has said, I'm going to really, he's been pretty chest thumping and saying, the government's acting totally unfairly, and I'm going to bring a series of motions and suggesting, a whole new Hunter had been lying low and playing it quiet, and under Abby Lowell, and perhaps to the chagrin of the White House during an election year, Abby Lowell has been playing it very aggressively on behalf of Hunter Biden. But I've said two things. The first thing I've said is I do think that the way things unraveled and then proceeded with really the biggest thing that intervened being all the screaming on the Hill by the Republicans really gave a very strong inference and reason to believe that Hunter had been basically prosecuted and big charges, had a misdemeanor had been converted into felonies because of his name. That's what's happening with the Republicans on the Hill. Obviously, it's their weak impeachment effort is somehow bound up, goes through Hunter to Joe Biden. They've gotten nothing so far, but they need Hunter to be dirtied up in order to even approach it. So on the one hand, it seems really like bad business, and like the prosecution has been responding to political pressures. On the other, and I've said this from the start, there's very little purchase in the law for what Abby Lowell and Hunter Biden want to do. It's very hard to vindicate the kind of claims they're making, in particular, this notion of selective prosecution. The law gives we're finding this out in some of the Trump cases too, to the upside, but a very narrow channel requiring a very strong proof. If you think about it, many defendants will believe they're being singled out for prosecution, and the U.S. Supreme Court has developed doctrine that gives them not very much of an opening to do it. So I've always thought that, notwithstanding Lowell's kind of braggadocio here, he was going to and notwithstanding the righteousness of his essential case, that is, that he's had the book thrown at him because of his last name, he wasn't going to really have much opening to vindicate that state of affairs. Now we'll see, because it'll be up to the district court. But the United States he filed to Biden a flurry of motions, and the United States has answered them all. They filed 4 responses yesterday. One has to do with the discovery dispute that we can set aside, but the other 3 are, this plea agreement is still in effect, and you've got to honor it. A plea agreement's a contract. You entered into the contract. You have to honor it. That's the first point. The second argument is, I'm being selectively prosecuted. You're doing this to show, for political reasons, because I'm a Biden, and that's unconstitutional. And then third, going off of recent Second Amendment jurisprudence in the courts of appeals, he's saying the gun charge is unconstitutional because this is where things are in Second Amendment jurisprudence, but it's unconstitutional to deny somebody the sacred right of carrying a gun just because they're using drugs. And that's what it comes down to. All right, let me march through each, and let me say, with the exception of the first, and that would depend very much on a sympathetic view from a district court judge and a little bit of massaging of the facts, or just bringing in fairness into it. He's got a long road. Okay, so on the gun charge, the charge itself is, he applied for a gun and said he wasn't using controlled substances when he was, and that's a lie. But there are 2 counts also that he used them that he had possessed a gun while he was using controlled substances. It's barely possible that second one will become a valid Second Amendment claim. I mean, that some of this stuff has been crazy, although Biden's been charged in Los Angeles, meaning it's the Ninth Circuit, which is not it may be crazy in some ways, but not in terms of guns. So I think that would be a long shot, but it doesn't matter so much, because I don't see any Second Amendment right that's abridged by charging someone who lies on a form. That seems to be a separate and valid crime. So I just don't think that's really going anywhere. The selective prosecution, I'm just a Biden, sort of feels right in the overall kind of, loose sense of what happened. And he says things that, there's a lot to be said for them, that the department is leaning over backwards to show that it wouldn't be prejudice against a Biden. And we know that Merrick Garland has been really at great pains to restore the credibility of the Department of Justice. And he's given David Weiss, not just a Trump appointee, but one who's worked this forever and has shown, to my mind, flawed judgment. Basically, complete, unencumbered, unsupervised authority. And the overall story works pretty well there's, when you tie it into the Republicans, et cetera. But it just ain't the story that the Constitution requires in order to have something dismissed for selective prosecution. In essence, you need to show, and this is an odd fit in a case where there's such a singular defendant as the president's son, but you need to show similarly situated persons who were treated differently or you need to show retaliation for the assertion of one's constitutional rights. And so the DOJ comes in and says he hasn't shown who all these people are who were treated differently. Now that's a matter, and this is where the fourth motion comes in, perhaps of getting discovery from the DOJ, because I can tell you anecdotally, and I've checked this with colleagues, people who do tax violations when they're in the depths of substance abuse addiction, and people who then pay it back, the DOJ doesn't throw the book at them. In fact, I can't find a single case in which people who were in fact, paid everything back were charged in just this way. Nevertheless, there are certainly people who have been charged this way. So it's a matter of how sort of fine grained you paint the whole facts here, and they paint them very luridly. So all of a sudden, from the misdemeanor, we start out in the DOJ motion with he was, with quotes from his autobiography, beautiful things, talking about using crack, every 15 minutes and being, completely in the depths of it, and all the terrible things he did. They hoist him by his own petard with those very words and make him look like, a sort of druggy, gun-toting monster. And it's just going to be a tough sell, I think, because there's no one really to compare, to the Biden factor. I mean, you can take every other defendant in the world, et cetera, but there in general, the argument should be that other people are treated differently, but you have to prove both discriminatory effect and discriminatory purpose. So they say he didn't identify a similarly situated person who's not been prosecuted for the same crimes. Well, that's true, but he's been treated much more harshly. So it really, and he didn't establish purpose because none of the politicians he reads on Truth Social approved the indictment. That is, yeah, people are out to get him, but they're not the ones who made the decision. So they invoke the supposed, sanitizing, kosherizing aspect of this is just the DOJ doing its job, and other people are charged as well. But if you take the focus a little bit closer and have a kind of a appropriately pragmatic view of how political forces can sometimes work, at least in this case, you might see it differently. And that's, of course, the whole point and the flaw in the special counsel statute is, normally Weiss is a U.S. attorney. I was a U.S. attorney. In a case like this, you go through levels of supervision. It might go even to the deputy attorney general. Wait a second. Are we doing this the way we do other cases? DOJ really wants horizontal equity. And if they say no, the DOJ, will say, no, we can't bring the indictment that way. But that's not a constitutional right. The constitutional right is to be free from discriminatory purpose and discriminatory effect, defined as other people not being charged, as opposed to, he's charged with a felony here, but that is because the plea agreement broke down, which brings us to the third motion and the one of biggest focus. Okay, so it was like, first, a plea agreement is a contract, period, between a defendant and department, and is analyzed by contract law principles. And you can think of this, any lawyers out there, as a first-year contract problem. The U.S. attorney, Weiss's office, signs it. Hunter's lawyer signs it. There's got a little thing down there that says approved by the probation office. They have to be down with the specific terms of his going a year and keeping his nose clean and having drug testing, etc. Is that a necessary element for the contract actually to be executed, so that before it was signed, it wasn't done? Calling on my contract law very, very rusty skills. The answer to me is it's not clearly that. It just might be, they're calling it a so-called condition precedent, that the contract wouldn't go into effect unless and until the probation officer approved it, and it's clear the probation officer didn't approve it. Then there's an important line in there that's not cited where it says the parties agreed that the probation officer has to approve it. It's just half a sentence, but to me, it's a key half sentence. So on the one hand, I think it's likely that, they go to court to have it executed. I think it is, likely that it was a half step shy of an actual valid binding contract. Imagine that, an earthquake had happened just before they go to court. Would it be a contract? So it's a contract analysis. And I think a district court, I'm assuming that the arguments about imperfection in the contract formation maybe are technically correct, but I'm also assuming that there is play in the joints here, especially with the whole context of a criminal prosecution. So Biden, I think, has, the whole saber rattling of Abbe Law, I think, comes down to, one, not Hail Mary, but a pretty, challenging shot. You need a sympathetic district court judge who understands what happened here and is moved to try to, make it right and say, look, you guys really did agree to this. And they did. The DOJ, there's no doubt it did. They're trying to hide behind that the probation officer didn't initial it up there or down there, excuse me. So that's the question that will go to contract formation. If it's a contract, it's a contract, and the U.S. has to perform the contract, and we are back where we were before. So that, I don't think, I think his vindictive prosecution is going to be, it's possible, but not too likely. I think the Second Amendment challenge is not going to fly because it doesn't work for lying on the form. And we'll see how the district court responds in a sort of gestalt way to the overall claim that they entered into this, they agreed to it, even if not every I was dotted and T crossed, and now they're stuck with it. That's his best shot, and that's what will really be front and center when these motions go to oral argument in a few weeks. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.